My name is Danamek, and I will be talking about San Antonio versus Rodriguez. What is the 14th Amendment? The 14th Amendment to the U.S. Constitution, ratified in 1868, granted citizenship to all persons born or naturalized in the United States, including former slaves, and guaranteed all citizens equal protection of the laws. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of the law, nor deny any person with its jurisdiction with the equal protection of the laws. The Texas state system does not disadvantage any suspect class. It has not been shown to discriminate against any definable class of poor people or to occasionally discriminate depending on the relative wealth of the families in any district. Does the Texas school financing system interfere with the exercise of a fundamental right or liberty? Though education is one of the most important services performed by the state, it is not within the limited category of rights recognized by this court as guaranteed by the Constitution. San Antonio Public School was a very poor school district with a low tax base. Families and students that lived in this district and attended the public school had a low income. The funding was inadequate to fund the school at the same level as other wealthier districts in the area, resulting in poor performance in their district. The funding of the school impacted students and their performance at school. In Texas, public schools were financed primarily through a system where property taxes were imposed by local school districts. Because property values were higher in some districts than in others, school got more funding than other schools. For example, one district raised $26 per student, while another district raised as much as $333 per student. Demetrio Rodriguez, son of a migrant farm worker, was born in 1926, and he had to leave school to work with his family after the 6th grade. In the 1960s, he lived with his wife and 5 children in San Antonio, Texas. Their West Side neighborhood in the Edgewood School District was home to mostly exclusive Mexican-American families. Rodriguez had served in the military, and in 1968, he was a sheet metal worker at Kelly Air Force Base. He was well acquainted with the substandard condition of his children's schools. There are many issues surrounding this case. Was a Texas school finance system unconstitutional under the Equal Protection Clause of the 14th Amendment? Is a free public education a fundamental right? If so, what is the role of federal government in ensuring that the rights are guaranteed in a manner that aligns with the 14th Amendment's Equal Protection Clause? These questions are at the heart of the San Antonio versus Rodriguez Supreme Court case. The main question about this case is education a fundamental right for purposes of equal protection under the 14th Amendment? There is no mention of education in the Constitution. Thus, there is no explicit constitutional guarantee. The question is now one of whether education is simply a fundamental right. The San Antonio versus Rodriguez case, in which the Supreme Court of the United States held that San Antonio Independent School District's financing system, which was based on local property taxes, was not an unconstitutional violation of the 14th Amendment's Equal Protection Clause. San Antonio is a city that prides itself on the Mexican-American heritage, but since the 1970s, researchers have realized that economic segregation, the stark contrast between rich and poor sides of town, is on the rise. In that regard, San Antonio topped the charts. School districts and local governments are not required to address inequalities based on income. It was just too complicated, woven into housing, the lack of economic opportunity, and all the other inequalities that the Supreme Court wasn't ready to take on. On May 16, 1968, 400 students at Edgewood High School in San Antonio held a walkout and demonstration and marched to the district's administration office. 90% of the students in Edgewood District were of Mexican origin. Among the students, the lack of qualified teachers was significant. The walkout also included parents of the Edgewood School District as well. On July 10, 1968, Rodriguez and 7 other Edgewood parents filed on behalf of Texas school children who were poor or reside in school districts with low property tax bases. They claimed that their school district had one of the highest tax rates in the county, but only raised $37 per student, while other schools in the district, such as Alamo Heights, raised $413 per student. In 1971, Rodriguez and his family brought the case to a federal court, declaring the Texas school finance system was unconstitutional. The federal district court three-judge panel ruled in favor of the Edgewood parents group, finding unanimously that education was a fundamental constitutional right and that the Texas school finance law created a wealth-based classification that deprived children in poverty-poor schools of their equal protection guarantees. The court ordered the state to restructure its school finance system to correct these inequalities. On March 21, 1973, the Supreme Court ruled 5-4 against Rodriguez, stating that the system of school finance did not violate the federal constitution and that the issue should be resolved by the state of Texas. It also held that the state would not be required to subsidize poorer school districts. This ruling, in effect, produced additional legal barriers to equalization. Later that year, the court denied a hearing on April 23, 1973. Justice Thurgood Marshall, however, called the decision a retreat from our historical commitment of equality of educational opportunity. Rodriguez responded to this decision. "The poor people have lost again," he said. Later in the same year, Jose Carnedas, superintendent of the Edgewood Independent School District, organized Texans for Educational Excellence, which devoted attention to the school finance reform. The battle of educational inequality continued with Edgewood versus Kirby in 1984. The Edgewood Independent School District versus Kirby was a landmark case concerning public school finance. The Mexican-American Legal Defense and Educational Fund filed suit against Commissioner of Education William Kirby on May 23, 1984. In Travis County, on behalf of the Edgewood Independent School District, San Antonio, citing discrimination against students in poor school districts. Back to the San Antonio versus Rodriguez case. Justice Potter Stewart concurred with the decision, stating that while the Texas educational system, like that of almost all states, was chaotic and it was unconstitutional. In San Antonio versus Rodriguez case, Justice White declared that the Texas system cannot withstand racial bias review. It would be a more constitutionally appropriate system if it ensured minimum educational expenses in every district through state funding, while extending an optional on all local districts to increase their pay per student. Justice Thurgood Marshall disagreed and wrote a strong dissent. He asserted, "The majority holding can only be seen as a retreat from our historic commitment to equality of education opportunity and unsupportable in a system which deprives children in their earliest years of the chance to reach their full potential as citizens." The Supreme Court of the United States held that, where wealth was involved, the Equal Protection Clause did not require absolute equality or precisely equal advantages. The court found that the Texas system did not operate to particular disadvantage of any suspect class. The court rejected the lower court's finding that education was a fundamental right or liberty. The strict test was inappropriate. The court applied a standard of review that required only that the state of Texas systems bear some rational relationship to legitimate state purposes. So to conclude, in simpler terms, no, there was no fundamental right to the education in the Constitution, and that the system did not systematically discriminate against poor people. Thank you.